I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right.
As this court is well aware, things happen in plea hearings and, sentencing hearings. As this court is well aware, things happen in plea hearings and, sentencing hearings.
I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal.
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the LIDEAHO4 case. And while I'm still not recovered, this recovery process is really slow. Apparently I have some type of pinched nerve, so my neck, back, my right shoulder to make these videos is killing me, but I couldn't wait any longer because after what I've seen today, and then all the things that I've looked at here in the last week or so, I mean, I've read the book, I've seen all of the series, I've looked at all the interviews, and everything that I see, I just shake my head. And then after today, watching the hearing, reading what the defense posted yesterday in their reply to removing that non-dissemination order, and then I look at all the coverage around the case and I go, my goodness. I mean, I just live in a totally different world than everybody else, I guess. I see things absolutely night and day from I guess, everybody. So I couldn't wait any longer, even though I'm in a lot of pain, and I'm probably not going to be back to videos every day for a little while now, but I'm going to put this one together for you, and we're going to do a massive breakdown of some potential bombshells coming our way. And it doesn't take a rocket scientist, I wouldn't think, to figure out between the hearing today, a few of the documents that have been filed, the cases that are cited by both the defense and the judge, words that you heard Bicca Barlow say in the beginning of this video, there is some potential fireworks on the horizon, and I want everybody to be aware of them, because if they weren't potential fireworks, then we'll reason out how things just wouldn't make any sense. So with all that being said, we're going to do a big deep dive to that hearing today, the motions that were filed by the defense and by the media company, and I'm going to point out some glaring things, and we're going to look at some case law as well. And by the end of this, I hope to wrap it up in a bow. Hold on to your hats, folks.
All right, we are on the record in State v. Koberger, CR 0124-31665. Present today by video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss the media's request to terminate the non-dissemination order. The state filed a response.
Let's take a second here and take a look at Koberger. Now, I've heard people all day long talking about how he's not in a suit. He's in his prison prison jumpsuit. And I can clearly see looking at him right here in this room, and that doesn't look like concrete block walls. Those look like painted sheetrock. He's in a little office room. Doesn't look like any kind of jail room that you would do a Zoom hearing for court in that I've ever seen on TV or anywhere. And he's not wearing a prison jumpsuit. He is wearing a undershirt and a maroon t-shirt. I mean, that's not a jail uniform. That is a t-shirt with an undershirt. This does not look like any jail setting I've ever seen in my life. So what is going on with this?
Indicating it was no longer objecting to that, and the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things here a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Wilson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here, because that was about information provided to the court. And given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Koberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you.
Okay, so that was the response from the media company responding to the objection, basically, or the opposition motion that the defense filed in not releasing the non-dissemination order. And then you hear Becca Barlow respond to their response, or reply to their response in oral argument. So now we got to figure out, what are they replying and responding to? What is the defense's argument? And what can we figure out from looking at some of this? Because the media filed a motion to remove the non-dissemination order. The prosecution filed a reply that said, you know what, we don't care about the non-dissemination order anymore because Koberger's accepted the plea deal. We'll withdraw our objection. We figured the defense would follow suit, but they didn't. They followed with this document. And it's very interesting as we go through this. It's the defense's opposition to motion to vacate the non-dissemination order. And what they're asking for is they request the court for an order to maintain the revised amended non-dissemination order that was issued way back on June 23rd, 2023, and they simply ask for it until sentencing. Right? So we're only talking about another 7 days, right? But when we look at it, first it starts with Mr. Koberger's request regarding the order is based on and they're going to go through 3 different parts to this motion or this opposition motion. The first one is real simple. The language of the order that had not been previously challenged by the media. When it says the language of the order, it means the language of the order that was issued on June 23rd, 2023, which stated until sentencing. So the first thing they're pointing out is the obvious language of the order, and it's amazing the judge is going to overrule this motion and release the non-dissemination order regardless of what the order actually said. And they pointed out language of the order. The judge, I mean, if the defense files a motion to save puppies, the judge would be like, no, we got to kill all the puppies. It's insane. But the second part is ongoing publicity regarding the case and threats to Mr. Koberger's safety. Now, we're going to have a discussion about this, but I'm going to keep on with what I'm doing here for a minute, because number 3, they've redacted it out. And you know me, I love a good mystery and I like to try to solve things, and I believe I have. But something and the hold order for all witnesses issued by this court. So we know the hold order for all witnesses issued by the court was the hold order that Judge Hippler issued to both the prosecution and the defense when he was talking about assigning the special prosecutor to do the investigation into the leaks. So we'll dive into that a little bit deeper here in a minute. But first, we're going to start with just simply the language of the revised amended non-dissemination order that was issued on June 23rd, 2023, and it specifically ran through sentencing. In response to significant litigation and an Idaho Supreme Court ruling, see a little footnote 1, on this issue, in this case, so not just a Supreme Court ruling on an issue in an Idaho case, but on this case, the court issued a revised amended non-dissemination order on June 23rd, 2023. By its terms, the order was to remain in full force and effect until the conclusion of a trial and any sentencing proceedings that may follow. Then there's the caveat, unless ordered by this court. So Hippler just showed that the Supreme Court doesn't know what they're doing. He just ordered by this court to remove it prior to the sentencing proceedings. But after this order was issued, the interested parties herein after the media raised no further objections to the revised order. The revised order recognized that Mr. Koberger's rights extend beyond the questions of guilt or innocence to his right to a fair sentencing proceeding, regardless of whether that proceeding is reached via a jury verdict or a plea. The motion filed by the media to vacate the revised order asserts that once a guilty plea is entered, that his right to a fair trial under the Sixth Amendment is extinguished. So the media is saying because he entered into the plea that his rights under the Sixth Amendment to a fair trial is extinguished. I would think that they would be as well, wouldn't you? And if Koberger enters a plea of guilty, bypassing a trial and going directly to sentencing, well then what would his right to a fair trial, how could that even come into play? There is no trial that's going to happen. And I've listened to a lot of people go through this particular document now, and they all get to this part right here, really this line, and then their brain melts down. And all they can come up with is there must be things that are so terrible that's hidden in the documents and in the non-dissemination order that if people seen it, then they would really want to hurt Koberger or the defense team or whatever, his family. And I'm sitting here going, what, are y'all insane? I mean, what could there possibly be hidden from us that would make people even more mad at Brian Koberger that believes he's guilty for the crimes that he committed. I mean, is there anything you could put on top of those crimes that would make you even, more disgusted and mad to want to go and hurt the guy? I don't think so. So when they have that brain meltdown, old Pop's thinking about it in a different way. And I am thinking about, why are they doing it? Because if they're not protecting the right to a fair trial under the Sixth Amendment, why would they care if the non-dissemination order was to be removed? If the sentencing is going to go down just like everybody thinks it is, with an agreed upon pre-planned deal, then what is discovery and the non-dissemination order and sealed documents? I mean, it doesn't affect anything. The judge is going to make the determination of sentencing. He cannot sentence it for more than 4 life terms and the burglary charge. He can't give him the death penalty. All he can do is reduce the sentence. So some of the arguments in here, if you think about it from, just a linear level, there's got to be something that's, that's outside of the box that we're not seeing directly. And let me point out one other thing before I continue on this, because y'all have heard me say this 1,000 times with Bill Thompson. Whenever Bill Thompson enters into a plea agreement with all of those people we've talked about up there in Moscow, I always point out when he does his Rule 11 plea agreements. And a Rule 11 plea agreement is when the prosecutor and the defense agree to terms on a deal, and the judge, if he accepts the Rule 11 plea agreement, he cannot vary his sentence from that Rule 11 plea agreement. It is a bound, locked in stone agreement. And that's why all the attorneys in Idaho say that you'll never find Rule 11 plea agreements on any kind of major case. And yet we found them on many cases that I believe are involved in this case. But this plea agreement that Thompson has made with Koberger and the defense team is not a Rule 11 plea agreement. Judge Hippler would have never accepted a Rule 11. This is a Rule 9, which means the judge can do anything that he wants other than up the penalty in the case. So the fact that this isn't a Rule 11 and all those Rule 11s go down with Thompson is another thing that makes you look at this and go, wait, something's just not right here. But let's continue. And it says, what the media fails to recognize is that Mr. Koberger retains his right to a fair sentencing proceeding guaranteed under the 14th Amendment. And then they cite C State versus Morgan. Now I've gone through, and on these 3 cases right here, I've read the entire cases and the appellate record. And I just wrote you some synopsises here, but State versus Morgan is a sentence that was overturned for a judge using outside information in determining a sentence. So when they talk about retains his right to a fair sentencing proceeding guaranteed under the 14th Amendment, and that his rights include that sentencing, then they cite this state. This is their example of a scenario where a judge took it upon himself to impose a harsher sentence based on outside noise out of the case file. And we'll take just a quick look at that opinion just to show you why it applies to what they're talking about. Okay, so this is from the Court of Appeals in Idaho. This is State versus Morgan, December 31st, 1985. And here is what the defense is talking about. And it's the judge as he gets to the sentencing. And he says, basically to Morgan, my first consideration in sentencing you must be the protection of society and its people. A condition of your bond when you were originally released was that you were to have no contact whatsoever with your wife because of certain assaultive behavior on your part to that time or upon the children. Any contact with the children, that was a condition of your bond. Hang on, I may have this. No, that's right. It's been reported to the court that you immediately went out and violated that condition of your bond, that as a result of that, your wife was hospitalized. The court has, in addition to the report, the information from the Department of Health and Welfare, the Juvenile Services, and the reports of an investigator with regard to your stepson and some criminal activity that he's been involved in. And that report certainly leads the court to believe that you were behind his criminal activity. I see at this point no redeeming factor of any kind. I can't consider any kind of probation based upon your conduct in the past. You're leaving the area, you're walking out of the courtroom at time for sentencing in this very matter, secreting yourself away from the courtroom. So I ask you, do you know of any lawful reason whereabout you shouldn't be pronounced against you? And the judge gave him 5 years in the end. And his charges were stealing hubcaps from behind a seat of bleachers. But what happened was when Morgan filed an appeal, it turns out that the person that went to his wife and beat her up was her ex-husband, not Morgan. And the judge was going off of hearsay from some outside source, not from any kind of official record. And it wasn't even him. It was his wife's ex-husband that did it. And all the things that he took into consideration were just things that people had told him that were outside of the record. So the Supreme Court, or the appellate court, heard the case, said that sentencing was just as important as the trial phase, and that things could taint the judge in sentencing. So that's the case that the defense points out, and it would apply in this matter if, word got out and something Hippler didn't know of got to his ears, he could impose a stronger sentence. Now, that was State versus Morgan, and I believe in this first paragraph this is where all of the important information that the defense is wanting to get across here, this is where it's contained. There is more important information down here when we get to the redacted portion, but I think it pertains to what we're talking about right here, because I believe there's 2 ways the defense has strategically gone at this. The first way is they could possibly pull the plea agreement at the sentencing hearing. They could withdraw it. And that's why you hear Bicca Barlow say, there's all kinds of things that happen at sentencing hearings. And that's why they would want the non-dissemination order not to be released until then, because if they were going to withdraw the guilty plea, then everything would still be under the order to schedule a trial date. But the second part is, as Judge Hippler is going to describe later, is during an appeal. And when I look at these other 2 cases that the defense has cited, there's something that's very interesting about both of those cases that they include. And it went off like just a red flag meter in my ears when I studied the case law in those 2 cases. And you're going to remember these words because I've read them to you 1,000 times in documents. But the second part to this, the defense states, and his right to effective assistance of counsel. How many times have we said that? Under the 6th Amendment and the Idaho Constitution. And then they cite Estrada versus State. Now, Estrada versus State is a case that was overturned in Idaho for ineffective assistance of counsel due to the defense counsel not filing for suppression of a psychological exam for a non-death penalty case, as it is protected under the right against self-incrimination. Now, with a death penalty case, like this case has been, there was a psych evaluation that the defense did that triggered the state to be able to do the state psych evaluation, but that's because it was a death penalty case. Now that a plea agreement has been reached, it's no longer a death penalty case, and the prosecution is not supposed to be able to use their expert psych evaluation in the sentencing hearing for Koberger on the 23rd because it's not a death penalty case anymore. And that is protected under his right against self-incrimination. And it's kind of weird because that case was overturned due to ineffective assistance of counsel because they didn't file a suppression motion for that psych evaluation. And when we look at the next case that they cite, a defendant's right to effective assistance of counsel extends to all critical stages of the prosecution where his substantial rights may be affected, and sentencing is one such stage. And they cite State versus Wood. And as you heard, the Miss Olson make the argument there in the beginning of this video, or just a minute ago when Judge Hippler asked for her oral statements, she said she looked up the cases that the defense had cited, and she said although she agreed that sentencing is a critical stage, that the case that the defense cited didn't really line up with the argument about not releasing information prior to the sentencing stage. And she's right, because briefly in State versus Wood, and by the way, that is a terrible case. I'm not going to get into the specifics on it. As I read it, I went, oh my goodness. But it was a terrible case, but the Supreme Court stated that sentencing is a critical stage in a small portion of that case. And that's why the defense cited it. But I thought the other thing that was interesting in that case was the case was not overturned because they have to have two factors to overturn it. And one factor wasn't enough. And both of those factors, if they had it, would still have to lead them to the conclusion that the case that he wouldn't have been found guilty without those two things. And he still would have been found guilty. But they still, in the Supreme Court's ruling, specifically put in a caveat that there was an exception made regarding a psych evaluation, and that, in effect, was ineffective assistance of counsel because they should not have allowed that psych evaluation. They should have filed a motion against it. And I thought it was just interesting that both of those cases that the defense cites, both of them included caveats about a psych evaluation, and we know that there was psych evaluations done right at the end of this thing because we've covered them in detail. And I believe that is going to be the defense's, that's their way back into a trial when this thing goes to appeal, because he will have an appeal. But we're going to keep on moving. In this case, substantial dangers of prejudice to Mr. Koberger exist up to and through sentencing. Now, when they talk about dangers of prejudice, they're talking about from removal of the non-dissemination order. And you got to stop and ask yourself, what kind of prejudice could it possibly have? He's not going to have a trial. The judge has a pre-agreed upon sentencing plan. He can't give him more. All he can do is give him less. So why would the defense be so worried about additional prejudice? And I firmly believe that you've got to look at this as either they're not going to go through with the plea agreement, they're going to back out and go to trial, or they're going to hammer hard at the first appeal. As this court is well aware, there have been numerous leaks of confidential information to the press, and the avalanche of publicity continues with the release of the Peacock documentary, the Idaho student murders, the Amazon Prime series on July 11th, 2025, and the book by James Patterson on July 14th, 2025. So I've seen them all. I read every page of that book. It took me 4 hours. I've never read a book that fast. And I have a very low opinion of every one of those things because their facts are not right and they made up so much crap. And I'll be getting into that here in the next few videos. But lifting the revised order now, this close to the sentencing, would only increase the media frenzy and publicity around the case. Well, that would only affect the defense if they had a plan up their sleeve to try to get this thing to a trial somehow. And I have to believe, based on that they do. The ongoing publicity in the case threatens Mr. Koberger's safety. Now, see, this argument here doesn't make any sense. And I think this is just filler for this first argument and this third argument. because give me a break. His safety is not going to be affected anymore with him releasing the non-dissemination order after July 23rd than it would be before July 23rd. So it's just not a good argument. As set forth in Section 1, the amount of publicity coming before sentencing, even with the revised order in place, is massive. Further release would only serve to gin up the anger and violent rhetoric already at a fever pitch. Now, I don't think you can gin up any more. Again, this court is well aware of the threats posed not only to Mr. Koberger, but to his family and to court staff. And I believe what Ann Taylor is saying, and to court staff, because later on down here, she's going to say attorney. I believe she's talking about the defense team as well. At this point, the press has access to every witness who is not an agent of either party. As the court noted in its denial of the motion to vacate the amended non-dissemination order in 2023, the media is not being restrained, only the parties are restrained, and those restraints are reasonable. Both parties had no objection and indeed sought to have the revised order remain in place at least until sentencing. And then in the footnotes here, you've got Peacock TV. This is the Prime Video, and then this is Patterson's book. I'd take Bloom's book any day of the week over the Patterson book, because although Bloom embellishes and makes up stuff, he doesn't do it anywhere near as much as the ridiculousness in this Patterson's book. And they got so much wrong. It's ridiculous. Made up bull crap. Court security resources were at a maximum capacity on July 2nd. The sentencing hearing, scheduled for 2 days, promises to be even more taxing on those resources. Lifting the non-dissemination order now is likely to change the atmosphere near the courthouse and may well push security needs beyond capacity. And what they mean by this is not what these morons out there are saying, well, there's something so bad in here, it's going to make everybody enraged. There's nothing in the documents or anything that they could bring to light that's going to make the crimes any worse than they were. So that's just ridiculous. What they're talking about is the spectacle around the courthouse. But then as we get to this argument, this is another one where you have to stop and you have to think, if they weren't still planning on using this to their advantage somehow, then why would they even care about it? And that is the fact that the court has issued a records hold order, and what's blocked out right here is "and special prosecutor / investigator." This is the person that was assigned as a special prosecutor to investigate the leaks. And this is what they're talking about. And if they didn't still have a play to make, then they would not still be waiting and trying not to impede the special prosecutor to complete their investigation, folks. After the release of the May 9, 2025 Dateline special on this case, the court issued hold orders to both parties. Documents and records hold order May 15, 2025. And then you've got this blacked out section. In its response to the media motion, the state now withdraws its request for the non-dissemination order to be continued until sentencing. The state cites further reflection and continues that, and we'll read that in just a second, but first, I went back to the documents and hold order the defense is referencing, and I believe I know exactly what's blacked out of this line, and Hippler wanted this blacked out because he doesn't want to remind anybody of this particular issue. All right, so when you go back to the document and records hold order, you can just insert this into that line. Based on sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to this case and the defendant Brian Koberger, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. So you just take that statement and plug it in right here, and it fits perfect. And that's why it flows with, in response to the media motion, the state now withdraws its request. This is what the state said in their reply. Out of their respect for the integrity of the judicial process and the privacy of the victims and their families, as they consider their rights to provide victim impact statements at sentencing, the prosecution team does not intend to make any public statements about this case until after sentencing has concluded. Oh, they don't intend to make any statements. The defense follows that up with the state's promise rings hollow, which means it's a bogus promise. It's full of crap, given the previous leaks from sources close to law enforcement. In the footnote, they say, from the language, who is promising not to speak to the press is vague. Does this mean the attorneys, staff members of the prosecutor's office, and or all of the 150 law enforcement officers involved in this investigation? On July 2nd, 2025, an entire row in the courtroom galley was occupied by law enforcement who were watching the proceedings. Will a third of the courtroom now be allocated to law enforcement, free to provide media interviews as they enter and exit the courthouse? And then they finish up in their conclusion, Mr. Koberger requests the court deny the media request. So he immediately didn't, because they said that, to vacate the revised order ahead of sentencing in order to maintain the integrity of the process, security, and safety of all the parties involved, including the families, court staff, and attorney, so Ann Taylor. The revised order should remain in effect. The revised order is reasonable in scope, does not impinge on the media's ability to investigate and report on this case, and maintaining the revised order will minimize the media frenzy leading up to the sentencing. So I believe the defense wanted that to be in place in case Koberger withdraws his plea, and I believe the judge overruled this as a reason to try to start getting information out there so that Koberger doesn't withdraw his plea. But that might not be the only place that they attacked. It's either going to be at withdrawing the plea or it's going to be at their first appeal. And that won't be too long down the road, and I'll show you here in a minute. But let's go back to what Hippler ruled on, and then I'll show you what we're looking at after that.
All right, as the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing because, frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. At this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, while certainly not to minimize those, they are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like water will find low ground. In this case, the media is going to write about something regardless about this case. The lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak, and the state has indicated that they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need and request. In terms of, for example, the defendant's family and others coming and going at the sentencing. We intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to
Okay, so just so there's no confusion, here's what Hippler just did. We're going to go back over here to the motion from the interested parties of media trying to get the non-dissemination order removed. And where they really dive in is right here in the introduction. And it says that on July 2nd, Brian Kohberger pled guilty to the unalivings of 4 University of Idaho students and a 1 count of burglary. Mr. Kohberger's plea sharply changed the Sixth Amendment fair trial, First Amendment balance in this case. He will never face a jury to determine his guilt, nor will a jury have any role in determining whether the death penalty is the proper punishment. All that remains is for the court, not a jury, to impose a sentence. And that is scheduled to occur on July 23rd. Both parties have waived a pre-sentence investigation. Mr. Kohberger has agreed he will not argue for anything less than consecutive life sentences without the possibility of parole. And he has agreed not to appeal. The nearly 3-year investigation and prosecution of Mr. Kohberger has come to an end. So what they wanted in this first part is all the people that were involved in the case, law enforcement, officials, anybody, to be able to talk to the media without threat of being bound by the gag order. So when the judge rules, no more non-dissemination order. That means that technically everybody that had any kind of involvement in this case can now talk to the media and give information, and they're not bound. However, the second part to their argument was, as this court has acknowledged, this case has been marked by secrecy. More than half of the nearly 500 orders entered in this case, approximately 246, have been orders to seal. The declaration of Rebecca Boone in support of a motion to be heard and unseal records is where they're citing that. But since January 1st, 2025, just this year, over 150 orders to seal have been entered. From what the Media Coalition can discern, the primary justification for most of the motions to seal and orders to seal has been the need to preserve Mr. Kohberger's right to a fair trial. But with the change of plea and the terms of the plea agreement, there is no longer a trial that's going to take place. So they wanted 2 parts. They wanted people to be able to talk, but they also wanted all these documents that are sealed to be unsealed. And the judge granted removing the non-dissemination order for the first part. But when he starts talking about the second part, which is all the stuff that I want to see, then he's going to give a little bit more clarity, and he is going to align with the defense's argument for some reason.
point out what that means and what it doesn't mean. So obviously, nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright, the request to intervene, because I think it's premature at this point.
All right, so that's where the red flags kind of go off again. So you hear the Hippler say, all right, so everybody can talk to the media now. You don't have to if you don't want to. But then when he gets to unsealing the documents, which would actually have an effect on any kind of 4D chess moves the defense might be making, he said, no, I'm going to deny that motion. We're going to keep those sealed. And then he's going to discuss a process after the sentencing where they will go through and start unsealing the records. So he knows that something may come up at sentencing, and that's why he wasn't going to unseal any of those things before that. And then he also said the hold order is still in effect. So the motion to preserve all of the information from the leakers, that special investigator prosecutor is investigating right now. And if it wasn't going to have any kind of impact for the defense, they wouldn't have put it in their motion, and the judge acknowledged it and he affirmed it. So really, for the first time, the judge has sided with the defense on this motion 2 out of 3. So very interesting. Now, before he goes into all the details about how he's going to unseal those sealed records going forward after all the sentencing and everything's done, but before he does that, he touches on something that I showed you in the very beginning of this video that is interesting. Let's listen.
In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement, but nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out.
So you heard Hippler talk about the appeal, and he cites U.S. Supreme Court case Garza v. Idaho. And this is where the rubber hits the road, folks. Petitioner Gilberto Garza Jr. signed 2 plea agreements, each arising from state criminal charges and each containing a clause stating that Garza waived his right to appeal. Shortly after sentencing, Garza told his trial counsel that he wished to appeal. Instead of filing a notice of appeal, counsel informed Garza that an appeal would be problematic given Garza's appeal waiver. After the time period for Garza to preserve an appeal lapsed, he sought state post-conviction relief, alleging that his trial counsel had rendered ineffective assistance by failing to file a notice of appeal despite his repeated requests. So he took 2 plea agreements, pled guilty, and then he wanted to appeal that shortly after his sentencing, but his attorneys wouldn't file the appeal, so he filed an appeal for post-conviction relief with the appellate court, lost. It went to the Idaho State Supreme Court, lost that one, but then it went to the U.S. Supreme Court, the real law of the land. And here is the outcome once it got to the U.S. Supreme Court. And now this is the ruling law of the land as it relates to appeals when you sign a plea agreement and a waiver of your right to appeal. The opinion of the court, U.S. Supreme Court. Idaho maintains that the risk of breaching the defendant's plea agreement renders counsel's choice to override the defendant's instructions on a strategic one. That is not so. While we do not address what constitutes a defendant's breach of an appeal waiver or any responsibility counsel may have to discuss the potential consequences of such a breach, it should be clear from the foregoing that simply filing a notice of appeal does not necessarily breach a plea agreement, given the possibility that the defendant will end up raising claims beyond the waiver scope. And in any event, the bare decision whether to appeal is ultimately the defendant's, not counsel's, to make. Whereas here a defendant has expressly requested an appeal, counsel performs deficiently by disregarding the defendant's instructions. We now address the crux of this case. whether Flores-Ortega's, and that's a different court case, Flores-Ortega, whether its presumption of prejudice applies despite an appeal waiver. Now we're going to go down here to the ruling. Instead, we reaffirm that when counsel's constitutionally deficient performance deprives a defendant of an appeal that he otherwise would have taken, the defendant has made out a successful, ineffective assistance of counsel claim entitling him to an appeal, with no need for further showing of his claims merit, regardless of whether the defendant has signed an appeal waiver. So all that you have to do to get your appeals back is show any area where the counsel was deficient. You know, like Ann Taylor says, the efficiency of a counsel over and over and over. Because once you show that your counsel was deficient in any way, you don't even have to follow up with the merit of your claim that they were deficient, and it automatically gets you back your appeal. It's like a fail-safe. Effective assistance of counsel. Goodness. Those whose right to appeal has been frustrated should be treated exactly like any other appellants. They should not be given an additional hurdle to clear just because their rights were violated at some earlier stage in the proceedings. We accordingly decline to place a pleading barrier between a defendant and an opportunity to appeal that he never should have lost. So anywhere you show ineffective assistance of counsel, you don't even have to show it by the merits. You just have to point it out and you get your appeals back, basically. U.S. Supreme Court. The more administrable and workable rule, rather, is the one compelled by our precedent. When counsel's deficient performance forfeits an appeal that a defendant otherwise would have taken, the defendant gets a new opportunity to appeal. That is the rule already in use in 8 of the 10 federal circuits to have considered the question. And then they go on to say, and neither Idaho nor its amici have pointed us to any evidence that it has proved unmanageable there. That rule does no more than restore the status quo that existed before counsel's deficient performance forfeited the appeal. And it allows an appellate court to consider the appeal as that court otherwise would have done on direct review and assisted by counsel's briefing. And that's important because it talked about, if that wasn't in play, all the people that were trying to do it pro se, meaning without a lawyer. But the Supreme Court's rule says that you are actually assisted by counsel. We hold today that the presumption of prejudice recognized in Flores-Ortega applies regardless of whether a defendant has signed an appeal waiver. Boom. This ruling follows squarely from Flores-Ortega and from the fact that even the broadest appeal waiver does not deprive a defendant of all appellate claims. Accordingly, where, as here, an attorney performed deficiently in failing to file a notice of appeal, despite the defendant's express instructions, prejudice is presumed with no further showing from the defendant of the merits of his underlying claims. The judgment of the Supreme Court of Idaho is therefore reversed, and the case is remanded for further proceedings, not inconsistent with this opinion, which means open it back up, make it match this opinion, and do it again, and let him have his appeals. But this is where all the rubber meets the road. All the defendant has to do is show one stage of the trial that he had ineffective assistance of counsel, which Ann Taylor's brought up 8,000 times, and it automatically restores all of his appellate claims. And they have to look at it just like he's a normal offender that went to trial and was convicted and is appealing. Now, there may be consequences such as when he does that, they could still seek the death penalty, but that is a big opening that Judge Hippler points out himself.
So the court will intend its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
So Olson, do you have any questions?
And I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests. We appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
Thank you, Your Honor. We appreciate that.
all right. And with that, then we are adjourned. Thank you. I'll see you next week.
Thank you, Your Honor.
Now, people are going to think I'm crazy, but I see the two outs. And one is withdrawing the plea at the sentencing hearing. And one is playing just a little bit longer game, going with ineffective assistance of counsel and filing the pleas after the sentencing. And, looking at the strategy both ways, I'm going to put my money on them pulling the plea at the sentencing hearing. I think all the tea leaves are pointing that that's going to happen. Now, I may be totally wrong. Heck, they may make Koberger get up there and give details about the crime and shock us all. But I don't think so, because we all know too much about the details of this crime for him to even have the ability to do that. So my guess is, based on everything I'm seeing, is they're either going to try to withdraw the plea at the sentencing hearing, and that's what I think they're going to try to do, or they're going to go with the ineffective assistance of counsel on post-conviction relief right after. And the reason I'm so confident in two of those things happening is because right before I got injured on this dang job, I had some information I was about to expose. And I've been sitting on it now for over a week, and I can't wait to bring it to you. And I'll bring it to you real soon. And it is some bombshell stuff. But I'm easing back into this thing. It's so painful just to sit here and try to talk on this microphone and click buttons on this computer. But I'm going to keep working out and getting back to 100%. And I'll probably start throwing you a video every couple of days now until I can get back into the rotation of feeling well enough to hit it every day again. But please like and subscribe to the channel. Thank you for everybody out there that supported me and continues to support me. Y'all mean the world to me. And please post your comments, your thoughts, your criticisms. And until next time, Pavarotti's out.